Доброго дня.
Good afternoon, dear ladies and gentlemen. Again, we have the last call, the last but not the least webinar on local elections 2020. And today we are going to discuss a very important issue on the protection of the rights at the local elections 2020, the procedures that are there, and designated authorities to handle the complaints and whose complaints they are considering and what could be the scenes at the issue. Today we have Olga Kutsuruba, senior advisor of the Opora NGO and representative of the CSC. The webinars are organized with the support of the Council of Europe project on inclusivity, fairness, and transparency of electoral process and human rights platform. I'm Alexandra Burbagin, executive director of the NGO. Today I'm going to moderate the discussion and be one of the speakers. We have Victoria Glushenko, the member of the C, with us too. Apart from their own judgments and comments that the speakers, experts are going to express today, feel free to raise questions, ask questions in the comments. We are going to go through them with the experts, and hopefully you'll get exhaustive answers to the issues that are pending. So let's get started with today's webinar, and the first thing on the agenda today is introductory comments. Historically, there are two models existing that are resorted to when protecting the rights, freedoms, and the interests at the election process of different subjects. That's the complaints submitted to the commissions or the complaints submitted to the court. That's with respect to action and inaction. At different stages of our development, these models were used differently in terms of the proportions and in terms of designated authorities, whether these are commissions or courts. There were different procedures to handle the submitted issues. At some stage, a lot of issues at hand could be subject to parallel appeal with the commissions and with the courts. Starting 2010 or 2012, we saw the evolution and delineation of the mandates between the courts and the commissions. Part of the powers were taken away from the electoral commissions, and in the slide you see the issues dealing with campaigning. And it was a long time ago when electoral commissions were saying that they don't have the time or desire and expertise on many issues to handle very complex issues dealing with campaigning. And starting around 2012 or so, the electoral commissions were removed from these powers, and at the moment they don't handle these disputes. They can be considered either by law enforcement agencies, if that's administrative offenses, or it could be considered by courts. We can say that the new election code reinforced the process, if you wish, and a large number of controversial issues were delegated to the competence of the court. And in this slide, you can see that Administrative Code of Ukraine contains special articles. That's articles 268 until 279. dedicated to electoral issues, whereby they establish special procedures versus the standard procedure of handling complaints under the code with the specific time frame established with respect to the specific entities that can submit complaints, and therefore some of the articles contain some specificities with respect to different types of elections, presidential, parliamentary, or that just articles that deal with all types of elections. Articles 264 Oh, sorry, the Articles 6465 of the Electoral Code deal with the complaints submitted to the commissions, and Victoria is going to speak about that in more detail. These articles, from my perspective, are narrow in terms of the subjects to be considered. Usually, that's action or inaction of the Commission as to establishing the results or contesting the results, decisions, action or inaction of the territorial commissions. So basically, the entire set of issues when it comes to campaigning is to be considered by courts. But as I said, it's not only about campaigning, but generally speaking, when it comes to the election disputes, because in reality, it is the court that is to consider all disputed issues, and if it is rights, freedoms, and interests exercised during the elections, to protect them, you need to go to court. I'm not going to speak about the complaints handled by the commissions. That's part of the presentations to be done by Victoria. As to the court procedures, what are the things to be remembered if you believe that your rights and freedoms are violated and you decide to go to court to protect them? Firstly, we have the 5-day period to file the complaint to court. That's 5 calendar, not working days. So Saturday and Sunday is taken into consideration too, as well as holidays. And an important thing to take into account here is is as follows. The time frame when it comes to the court proceedings, that includes complaints, are not renewed. So, in other words, if you miss the 5-day period deadline, you won't be able to renew it or substantiate the necessity of renewing it before the court, and thus you lose the opportunity to protect your rights in court or interests in court. Another important thing here to be considered, and that's directly established by the administrative code, that the day of submitting or filing the claim or appeal claim is the day of submitting it to the court. So that's the very day when you submit it, when you file it to court. That was a stumbling block for many lawyers, including experienced lawyers. In my practice, there were some instances when the materials were referred or submitted to court missing the day, because the day when the court received the documents already missed the deadline. So the mailing is not taken into account, because that's a special procedure, as I said, that the code established, and they say that the day of submission, contrary to general handling of the complaints, is not the day that you sort of post it with the mail or courier, but the day the court receives it. Actually, so not any other day. In election disputes, the day when you directly submit the documents to the court is the day. It's very interesting to look at the opinion of the judges on several things. The first updated version of the Administrative Code of 2018, similar to other procedural codes that were updated then, provides for the system of so-called e-court. Unfortunately, the system has not come into effect fully yet. Talking about elections, well, the thing that would be interest for us is the ability to submit the materials with all the annexes electronically. As of today, we have the register of court decisions. We have the portal judiciary. We can follow the procedures related to specific cases, automatic signing of the cases. So some elements of the e-court are there and working, but not all of them. And the most important one, from the point of view of the elections, that's the opportunity to file the complaints or the materials in electronic form. Why is it so important? Well, it's not on the slide, but here it is to do with the redistribution of jurisdiction or powers between different courts. Previously, a lot of disputes were handled by local general courts. These are the closest geographically to the potential applicant, the subject of the electoral process, and to the place where the violation subject to appeal was committed. Updated administrative code, though, redistributed the powers between courts, giving more powers to administrative district courts. And as of today, only some of the cases, when it comes to their jurisdiction, are to be covered by local courts. All others are referred to the jurisdiction, to the district administrative courts. Given the fact that district administrative courts are normally one per oblast, there is a huge issue with meeting the time frame of 5 days. The closer to elections, the more difficult it becomes, because we have the waiting like no later than the election day and things like that as an additional requirement. Given the distance of 200 or sometimes 400 kilometers to get to the district administrative court, that could be a physical obstacle on the way of filing complaints to contest the actions that the person believes unlawful, or it could be the instance of inaction. So that's a very important moment, and it's very important to hear the opinion of judiciary, including the opinion of the administrative courts as to the potential date of launching e-courts. In May, we had a roundtable on digital rights, and it was said then that they need roughly 6 months to complete everything and launch e-court. So that 6 months have already passed, and the e-courts launch have been delayed again. Anyways, you have to remember that 5-day deadline should be met, because you cannot renew it. If you miss the deadline, then your complaint is not going to be considered. So the day of submission of the complaint is the day of the actual receiving the documents by the court. And again, another important thing on complaints before the court. We have 2 instances only. When it comes to the court proceedings, the cassation stage is missing. In some instances, the Court of Appeal handles some of the cases, and there's the Supreme Court, a respective chamber there. But anyways, the court acts as the appeal. So the cassation procedure is not there, is missing. We have the first and the second instance. We need to handle these cases quickly, and this means that the court cannot violate the established time frame, though in practice sometimes it happens. Well, normally though the court handle these disputes in the course of 2 days. You have 2 days to appeal the decision, and the appeal is to be considered within 2 days as well. So from the moment the documents enter the court, we have 1 week max that is allocated by the administrative court to consider the case. The time frame is becoming shorter the closer we approach the election day, because the violations that were committed before the elections should be considered prior to the day of voting. So these are the most important things that deal with the complaints before the court. I will speak a little bit later about some specificities as well as course. Well, there are some things to be considered there, but first let's talk about handling complaints by the Commission. Victoria. Given the new electoral code that was adopted, the CSC approved the procedure of handling complaints by the election commissions. That's a uniform act, collection of all procedural important things as to the complaints, not only at the local elections, but at the presidential elections and parliamentary elections. What is a complaint in the election process? Complaints, that's the application that contains some facts as to violation of the election law and request to protect rights, interests, and freedoms of the parties to the electoral process and reinstate electoral rights. Under electoral code, there are 4 types of entities that can file complaints to the EC. The first is the candidate for the position of head of the village, town, and city community. The election code provides for some representation. On behalf of the candidate, it could be his proxy that could file the complaint. Here you should note that the candidate for the position of the leader of a village, town, and city council can submit complaint to the election commission only in the constituency where he or she is registered. Another subject to submit a complaint is local organization of the political party as subject of the election process at the respective elections. So, in other words, that's the party the candidate represents and that registered the candidate by the TSC. In this case, the proxy could be the authorized person from the local authority in a single multi-mandate constituency. The head of the political party can act without any additional representation. So, on behalf of the local organization, it is the representatives of the local party that can submit the complaint to the election commission. The person can go to the election commission of the level of the local party organization that nominated the candidate to the respective council. Another thing, election code provides that one of the subjects of submitting complaints to the local election commission is the authority authorized by the respective local party organization. That's a new provision of the election code. This person, when submitting the complaint, should produce the original of the decision that authorized the person to submit the complaint. The third subject, is it a letter of proxy that the person should have, or that's a similar document? Well, what kind of document should the party issue to authorize the person? That's the decision of the respective body of the party organization that is done in the format as per stated. So by this decision, the local party can authorize any person who is not a subject of the election process to submit complaints on behalf of the political party to election commissions. So that's a letter of proxy, right? Yeah. The third subject that can submit complaint is an official observer. That's a standard seen as a standard person who can submit complaints. When submitting this type of complaints, you need to take into account the boundaries of the constituency where the official observer is registered. The fourth subject to submit complaints is a voter whose rights or protected interests were violated. The voter, when submitting a complaint to the respective election commission, should substantiate the complaint, what were the decisions, actions or inactions his rights were violated. That's similar with court procedures. If it is a voter, then his rights are slightly limited because the voters should substantiate how their rights or lawful interests were violated and prove that. If the voter does not substantiate that, that could serve as the ground to leave the complaint unconsidered. If the voter substantiated the violation of rights but did not prove that in the complaint, that's the ground to dismiss the complaint. Thank you, Victoria. And the question as to official observers and NGOs, can they file the complaints? Are you going to? We'll see. Yeah, well, at the moment we are submitting just requests. We are not official observers yet. Official observers and NGOs. Well, indeed, we need to take into consideration the geographical boundaries. As a lawyer of an NGO, I was registered in all oblast TSCs. Well, unless it is done, then I would be limited in the right to represent interests. So these subjects of submitted complaints. Talking about the election commissions, it's only inaction of TSCs that can be a subject of complaint to the CEC, and that's to do with the results of respective local elections. Let me quote an example that we saw when TSCs set up constituencies. Kyiv? No, I wanted to quote different city. Rural electoral commissions, when establishing constituency, didn't manage to always meet the requirements to set up constituencies. Those who did it believe that they have the power to handle any complaints with respect to actions or inactions of respective of rural town and council commissions. But the powers as to establishing the results of respective local elections and all actions committed in the course of the election process cover the territory of respective village only. So the subject of handling complaints with respect to inaction of this election commission is only the CEC. If these rural town commissions issue protocols on the outcome of the elections to Rayon Council, then it is respective TEC that can handle respective complaints. Well, the previous webinars we spoke about the system of commissions and their relations, and then we spoke about hierarchy within the system of the election commissions. And CSC did mention that we don't have a clear delineation of subordination procedure among the TSCs, or among the election commissions, I'm sorry. And then it was said that the powers or hierarchy are determined by the fact which commission established what. You are talking about the villages now. It wasn't the CC that set them up. So, well, is this type of subordination effective only when it comes to contesting the results? Or when the CC is the highest authority with respect to any other TSCs? But the procedure of submitting complaints to the CSC or any Territorial Election Commission provides that inaction of the Election Commission that established the results of the elections is handled by the CSC. Rayon Election Commission is going to be superior with respect to village and rural one. When it comes to Rayon Council, the Oblast one is superior to Rayon Election Commission when it comes to organization of the elections to Oblast Council. The CSC is superior to rayons with respect to elections to the councils to Rayon Council. So the boundaries of the constituencies, that's an issue for all levels. No, village election commission sets up constituencies or boundaries of the constituencies for the councillors of the village council. So it depends on the powers of respective TSC. Paragraph 2 says that a TSC that establishes results of respective local elections. And here you can submit complaints as to decisions, actions, or inaction of the TSC of the lower level that establishes the results of voting at the respective local elections. So at Rayon Election Commission, you can submit complaints as to action or inaction of the village election commission because they are going to establish results of Rayon councils. Or it also deals with action, inaction, and decisions of the district commission PSC that organizes local elections. Territorial commissions can handle complaints as to the PSC that is in charge of organizing elections, local elections. And TSC that established respective PSC can handle complaints, action or inaction of the members of this PSC. So action or inaction of any member of the TSC can be submitted only to court. So to contest inaction of the election commission, you can do that only with the commission that set up a respective commission. So you can also file the complaints to court. If you recap these two slides, you can say that TSCs, when it comes to complaints, so they can handle the TSC's action. Well, if it is actions of candidates or their proxies, so you can do that. Well, enterprises, mass media, or anything like that. So commissions handle decisions, actions, and inactions of the commissions themselves, following the hierarchy, or the members of the commission. Basically, in what you were saying at the beginning, you answered this question too. We have experienced members of the TSCs, but unfortunately, given the limited time frame, it's very difficult sometimes to assess all scenes, for instance, when it comes to campaigning. So the court, as part of the court proceedings, have more time to substantiate and hear the issues on the merits. The TSC's decision on the complaint can also appeal to in court. The time frame for submitting appeals, the time frame has been decreased under the effective election code. At the moment, it is a 2-day period that was established by the code. We also have a special time frame of a contest in the actions that happened prior to the day of violation. You have 2-day period, but no later than 10 p.m. On the day before the elections. So that's going to be October 24, 10 p.m. That is going to serve as the deadline to submit all the complaints as to violations. Actions, inactions, and decisions of the members of the commission as to results, transporting the results can be appealed no later than the next day following the date of the decision being made. So, in other words, if you want to appeal any decisions of the city commission, so that's going to be no later than the day the Oblast Commission accepted the documents.
You spoke about experienced members of TECs. But again, at the previous webinars, we've had some discussions, and we said that it was quite a challenge. The 25th of October is going to be a challenge for everyone. And as one of the arguments that was expressed was that all the election commissions, except for the CEC perhaps, all the other levels, but the CEC too, in fact, all of them within the context of the election codes and this present election system and the mechanism of vote tabulation, documentation, they all have zero experience. The TECs, the DECs, the BECs, nobody has such experience to conduct such local election. You're right, because it's true that the election legislation changes permanently. Even now, draft laws have been registered to amend the election code, and it's true that the members of the TECs and the BECs are going to have a very hard time, because although the protocol, the reports are very complicated, there are too many ballots, it's a new election system that has never been used before. It's true, we can say that everyone has zero experience. And here, when we get back to the system of complaints, perhaps it would not be correct that the CEC cannot correct a certain member of a TEC. It can only be challenged with a court if we're talking about a member of the Territorial Election Commission, about one's actions or inaction. Well, that's a question to the legislators. They have decided who can handle the complaints, including the CEC. But the CEC has always only handled complaints about inaction of the territorial commissions, while the individual members' complaints about individual members would have to be lodged with the court. However, if one violates the rights of a candidate or a voter, one can turn to the police and hold one liable for interfering with one's election rights. Now, this can be done without any additional means, because such a member can in fact only perform registration, refuse to register, to write something down in the log, and primarily the problems may emerge when this violates a certain right of another person. And there one can have protection in the form of liability. In the same way, the CEC can terminate the mandate of a certain member of a TEC because of systemic or even one-off blatant violation if the CEC gets proper applications. One does not even have to launch a complaint, but to send an application which would argument the unlawful actions. Well, the recommendation is to turn to the police, while the commission says that they have more loyal, let's say, levers of influence, such as substituting someone or terminating one's authority. Well, if the CEC learns about certain violations, and there are certain elements of this violation, one can also turn to the police. Well, this present commission, they have always had this right, but now the Central Election Commission is really using it, and that makes us quite happy. While an election commission discusses whether the complaint has been lodged properly, the commission should also take into account that the day of filing the complaint is the day when the election commission has received it, and this period of time should not be renewed except for when the person sends the corrected complaint the following day after it was rejected. What's also interesting, If one gets an electronic complaint by email, then the election commission should still wait for that to receive the complaint on paper, or to be authorized with a qualified electronic signature. In that case, the day when the election commission receives the complaint on paper or signed electronically would be considered the day of receipt of the complaint. Well, of course, the requirements for the complaints are the same. They have not changed. The people who manage elections, they're already quite used to them. The only positive thing here is that in a complaint, one can mention the parties and the interested parties that the subject of complaint believes it is necessary to engage. This is not an imperative standard, because we know that earlier could be one of the reasons why the complaints could just be rejected. The complaint should also mention the status of the complaining subject in the election process. If this is filed on behalf of a candidate or his or her proxy, then there should be the name of the complainant mentioned, as well as the person in whose interest it has been filed, as well as the address, the formal contact address, the email address, etc. Now, as to the subject of application, of complaining, and its requirements, here, in view of the previous practice, no changes have taken place. One can always say that the complaint is not does not comply with the law. One can ask for renewal of one's lawful rights and interests of the subject of the election process. The formal reasons are if the complaint has been received without all the proper procedures or requirements according to this code, should be sent back to the complainant the following day. Well, the complaint that has been filed on the day before the voting day and on the election day would be sent back immediately. Okay, if this is 2 days and the next day it is sent back, then it expires. That the period of time expires. Well, as to the complaints that can be dismissed completely, the CEC head should sign and the deputy chairpersons should sign it, while the territorial election commissions, the right of sending it back or dismissing it is only awarded to the head or deputy head of the election commission. A complaint which complies with the code and the procedure should be discussed by the election commission at its meeting, and the overall period for that can be found, it is 3 days, no later than on the 3rd day after receiving the complaint. It should be discussed, and although there is a 2-day period for complaining, however, it can be discussed and reviewed during 3 days at the commission members. The code also establishes special time frames for the reviewing election-related complaints. It should be discussed and reviewed no later than on the 24th, then 0 hours on the day before the election, or within 2 days if it is complaint related to the tabulation of the votes. And if the complaint has been received by the election commission after the end of the election process, then the commission has 30 days to discuss it. The election commission may decide that it may be granted or it may be rejected. If the election commission decides to grant the complaint, it should also provide a proper assessment to all the circumstances described in the complaint, to assess all the evidence and make a lawful and justified decision. The complainant also has the right to clarify one's requests as described in the complaint. One also has to explain why one wants to correct it, why certain circumstances were not previously known, and 2 hours before the meeting, one can still do that until 2 hours before the commission starts discussing it. So if a commission gets together and starts discussing it immediately, then they don't have this right. Well, the election commission has to inform the complainant or his or her representatives that is going to be discussing this complaint at this meeting. And the complainant then should receive this information as well as all the materials related to the complaint, the evidence, everything attached to it. If it is granted, the election commission can make a decision with which it may decide that certain requirements of the complainant are not in line with the law. It can revoke the decision. It can renew the violated election rights in this or another way. And incidentally, talking about renewing or reinstating the violated election rights, the CEC has had some practice when it, in fact, forced the TEC, although the period of time is preclusive, but it had to take certain actions to make sure that the election rights of the citizens would be grounded. That's the principle of the rule of law. Does one have to pay any money? No. It's completely free when the election commission discussed the complaints. It's free. Well, that's actually the difference. While even the observers would very often turn to the election commissions, because this is free. And we understand that formally, perhaps if we analyze the old resolution, it was easier to send those documents to the judge, to a court, rather than to a commission. Perhaps now, because it used to say that it should be done, that the copies should be submitted according to the procedures as established by the law. It was not very clear how they should be established, Well, let's hope that the new resolution would have a different approach to it. Sometimes it is even more difficult to document the complaint, but at least that's free, because even such an organization as ours, we would then have to show the court fee and justify, especially why we lost that case, to justify to a donor why we have lost it and what kind of costs we have paid. So this way, especially for the village candidates on the local level, that's of course quite important, especially in view of the size of the court fee that we're still going to be discussing, and the fact that this court fee keeps growing depending on one's requirement. I have a couple of questions to you. To follow up this idea of bringing up the local election commissions and the spirit of the rule of law, you said that the CEC can terminate the mandate of a certain member. However, Facebook, when certain new facts have been discussed according to the election codes, I have read such, for example, questions: when will the CEC dismiss them all? So can the CEC terminate the competences of all completed commissions? Yes, if there is a blatant violation of the law. How would you say what is a blatant violation? Well, yes, that's judgmental, of course. Well, but maybe you have any practice. What would be considered, blatant violation or grave violation? Well, 2015, when we had the local election, then many times the competence of territorial election commissions were terminated because they didn't provide everything necessary for the election, to meet the election rights of the voters. For example, Mariupol, remember there the commission did not make sure that the ballots would be published. Certain election commissions would reject some candidates, would not register them, in which case all of the commission would be terminated. Well, for example, failing to execute the decision of the court. If the court says that the commission should take certain actions, the commission rejects it. The court can do that. Well, there are territorial election commissions that would not comply not only with the court decisions but with the decisions and rulings of the CEC, in which case the CEC would terminate the authority of all the commission. Okay, in simple words, if one fails to comply with the requirements and demands of the CEC, is considered to be a blatant or grave violation. That's a question to both of you. Most often, this mechanism, when is it used? And who mostly complains? Voters or the subjects of the election process as they challenge the results? What is the most intense period? Most often, the complaints come to the CEC from the candidates who have been registered to organizations of the political parties and the official observers, of course. You mean with complaints? Yes. These are the most frequent subjects. The voters very rarely send their complaints to the CEC, and if they do, then unfortunately those complaints are not in line with the formal requirements. Well, we can justify it, substantiate Apora. Do you often send complaints? Well, we rather send applications, appeals. We send appeals, applications of informative nature. We inform the CEC about certain violations. Of course, the CEC could use its right to discuss it within 30 days, although there is a special provision of the law in the CEC saying that if this is a complaint filed within the election process, they should have 5 days for it. That's why we're using it. No, that's for now. We're not talking about the complaints sent by official observers yet. However, if the registration has only just started, so one has to be registered first. Second, if I'm registered but I do not always have a copy of that registration certificate, then we would send an application. I would sign it, and we have to get our certificate back to make a copy of it, to always have it on oneself. So there are some technical issues where when you analyze it, you understand that the complaint can be dismissed or not even discussed because of some formal requirements, like, for example, that the original evidence has not been attached, then you have to do it quickly. I have another question about journalists. It's my favorite topic. Journalists have the right to be present, and they no longer can be present at all the events related to the election process. Traditionally, it was a part of an article about free and open nature. No, we know they no longer have this right. The journalists are already facing certain problems. So they don't have this right, but they have the right to be present at the meetings during the tabulation of the votes. So, for example, if this right of a journalist is violated, who should he or she complain to? The election code does not say that the journalist is a separate complainant. It's just a complainant, and the journalist is a voter in any case. Well, unless it's a foreign journalist. In that case, one would not have the right to file a complaint, and as a voter one can file a complaint. Okay, if I'm a journalist registered in Kherson, I live in Kyiv though, and my editorial board sends me to Chernihiv, a voter has to explain, to justify why his or her voting rights, election rights have been violated. What should one write in the complaint? As a voter, what electoral rights have been violated? Well, in that case, one's own election rights would hardly be violated because one would be performing certain labor functions, professional functions. Yes. So if in a situation as established by the election code, one has the right to be present at that meeting as a media man, then in that situation it would be better, I believe, to use other methods of having one's rights protected rather than a complaint to the law enforcement. Well, Article 151 of the Criminal Code, interfering with the lawful activities of a journalist, or if we get complaints, because we would not protect or defend candidates, but if journalists come to us, then we would launch complaints about violation of the journalist's rights. There we would challenge the actions of the commission, for example, to a higher level commission, or maybe even to a court. If this is a matter of principle, then our public ombudsman that we have in every region. Oh, thank you. So a journalist cannot file a complaint because of this issue of who the subject is, while the observers from representing a Opora network, they can't do it because they do not have any restriction in terms of the need to prove that their personal rights have been violated. Well, because the election code gives a special status to the official observers. That's their sacred mission during the election process, to be watchdogs of the law. Okay, let's hope that Opora will effectively use its sacred mission during this election campaign too, because unfortunately we already have some facts of the violation of journalist rights. Well, especially now because of the COVID. As far as I know, COVID is used as a formal ground not to allow a journalist to be present at the conference, for example, where candidates are nominated, or to other activities related to the election process. Let's continue our webinar. Let's get back to the courts. And here, as far as I remember, we used to have a kind of a matrix speaking about where one could turn in what kind of situations and what court of appeal can eventually hear certain cases. Well, that's basically summing up of what we have just discussed with Victoria and Olga. Again, we have said that a member of a PEC, if one's rights are violated, then one can turn to the TEC that has set it up, or to a local court, for example, located in that territory where the PEC is located. If you turn to the TEC and the TEC has not granted your request, or if you disagree, you can challenge it with the DEC, with the District Election Commission, and if you disagree with that, you can go to the first instance court, and if you disagree, you go to the Court of Appeal, and if you are not happy with it, you can go to the Court of Appeal of that territory. And there are two instances that hear election-related cases where there is no cassation. If a member of the Territorial Commission violates it, you can go directly to the DC, again at the location of the Territorial Election Commission. In fact, at the regional center you would find this district court, and again the question is, if we're talking about a village, let's say, commission, then one should go to the regional center and submit one's documents within that special period of time that we have already discussed. But at least district courts can work round the clock, unlike the local first instance courts, where we see that they usually don't work round the clock. And now they're dealing with complaints about the voter list, and for example, you cannot file a complaint with them that you have not been supported with your right to be present at all the events. Although, as we said at the previous webinars, they have to be there. They have to organize their work in such a way that they would be able to receive the documents round the clock. Well, somehow they forget that they also have to deal with complaints about actions or inaction of the PECs. Well, not only the PECs. We would see that the general courts, the trial courts, they should also deal with the situations related to the media, to the businesses, enterprises. Well, not every court would work like that. Well, I just remember from our previous practice, our lawyers, they have some funny cases when the court would be closed. It's 12 o'clock, the time would soon expire. They would break the windows just to get the documents inside. They would call the police to register the fact that the court was closed. However, it's not only the courts. Let me remind everybody that the police, the court administration, the agency responsible for maintaining voter registers, all of them within their competences have, according to the election code, to make sure that their work is organized in such a way that one can have one's rights and interests granted at any time. So members of the territorial election commissions, their actions or inactions can be challenged with the territorial court, and if one is unhappy with that decision, one could go to the territorial court of appeal, administrative court of appeal. The members of the Central Election Commission, and here let's have a look at the jurisprudence, because in that case such complaints would have to be launched with the administrative court of appeal in the appellate district that includes the city of Kiev. That's court number 6, and if one disagrees with that decision, you can turn to the court of appeal again, but it would be the court of appeal and a chamber of the Supreme Court. Now, we've already said that that's yet another situation when the local courts are to be involved, when you want to complain about decisions or actions or inactions of the media, or as well as organizations or institutions and their officials. For example, this is a situation when an enterprise, a business, would not, for example, rent out a building, a facility to a certain candidate while they have given it to another candidate, another subject of the election. The media, and here I would insist, and I keep telling the subjects of the election right that they should use this right. Unfortunately, I don't see this right to be used. Rather, it's the right to response. However, there have been such situations in the courts when this right to response would not be provided, and the media can challenge it, and in fact, in that situation, they should go to the local court rather than the administrative territorial court. And for example, when we see one's rights and freedoms violated, if you disagree with the decision of the local court, you can challenge it with the administrative court of appeal, which is located territorially or whose jurisdiction covers the territory where the case was heard by the trial court. There is yet another situation related to the local courts. So you see, they deal with quite a number of cases down there where a candidate to the village council files such a complaint. The local courts should hear them if their rights and freedoms of a candidate to a village council are violated. This is, let's say, the lowest territorial level. However, if a violation is carried out by the executive, by the local authorities or their officials, once again we would go back to the district administrative court located in that area, and if you disagree, again you go to the Court of Appeals whose jurisdiction covers the territory of the local courts. We don't have so many of them. Yes, there's only one to every 4 or 5 regions, oblasts. Yes, and it's quite difficult. And we remember that one only has 2 days for it, and it's one thing if you Well, if you appeal, then it's 5 days. Well, no, with appeals you only have 2 days. You have 5 days to turn to the first instance court, and then you only have 2 days to go to the Court of Appeal. So within 2 days you have to write the appeal and have the time to reach that regional city where this administrative Court of Appeal is located. Like, for example, you have to go from Uzhhorod to Lviv. Well, that's not the worst case, but there are bigger distances. And once again, we're getting back to this issue that this electronic system should start working within the election context, at least, especially in view of all those special time frames and the fact that they should not be restored or renewed.
Якщо
If that's a candidate to rural and village council, then it's local general court. If these are other candidates, so delineation here, rural village council, that's local general, and it also the candidates for the position of the leader in a village. So that's the local general court. All other potential subjects should go to the district administrative court at the place of commission action. And the general rule, that's a territorial court of appeal if you appeal the ruling. So you can also contest actions in action of the official observers from the subjects of the election process. And NGOs are not NGOs that have a sacred mission. So the administrative code does not provide for that. Well, there is a case law. If you look at it formally, the code of administrative code states that official observers are treated as subjects. I think that's the next slide on our matrix. They are covered by the article when you contest the action and inaction of the election commission, but the practice of the previous election proves that official observers contested unlawful campaigning, for instance, of candidates, and if it is the article with respect to candidates, then you can talk about public authorities and self-governments as well. So in other words, the Supreme Court interprets it broader and substantiates it, saying that the official observer is a subject of electoral process, and well, the fact that it was not mentioned in a respective article eliminates equality, and they handle the complaints. So this approach is based on the principle of the rule of law. Victoria, Commission is not here. Can we apply this with respect to commissions when it comes to the appealing or contesting the decisions of the PSC, DC, and TC? PSC is appealed at the local courts. It would be strange if you go to Oblast. TECs appeal it in the district administrative, and CSC go to Court of Appeal if that's the disputes on election process. If that's the tabulation, that's appeal. And we have the Grand Chamber there. Right. If there's disputes that go outside the election process, then the CC's action are appealed in the District Court of Appeal of the City of Kyiv as the court of the first instance, under a general procedure provided by Administrative Code without application of the special articles that we saw at the beginning, right? A few other things on appeals. There are formal requirements to the action submitted. There are requirements as to the action, what should be stated there, what documents should be annexed. Another important thing is about representation in election disputes, apart from the lawyers that should be there and other subjects that are covered. And well, the question about the election commissions, the head. Can it represent the Commission? There is a different practice. Sometimes courts open the proceedings if there is the decision of the TEC that authorizes the head of the Commission to act as a representative in proceedings. There are disputes, court disputes, where the head of the election commission, without any additional authorization, acted as a representative. And the courts, administrative courts, don't have any issue with that. So when it comes to the TC, they have experts and they have lawyers. There is a bigger issue with the PSCs. How can they have their own representative? Are there many instances when lawyers act as engaged persons at the TEC? Well, there could be contract agreement between them, yeah, but there should be respective decision. The electoral code provides for engaging respective experts to work at TEC on a payment basis, on the basis of agreement, and TECs naturally hire accountants and lawyers that later can represent their interests in courts, because subjects of the election process can have authorized persons and their proxies as representatives without additional documents to confirm the powers. So the ID would be sufficient in this case. And that's very important. Well, the ID and the document that would prove the professional affiliation. Yeah, true. So we know that as of yet, well, we know that the situation might be changed, but there is a monopoly of the bar at the moment and lawyers as representatives. And when it comes to election disputes, there is an opportunity to represent the subjects of the election process through proxies or authorized persons, and very often these are the lawyers with respective experience. Another important thing is the cost fee. There is a specificity here that primarily deals with the election list. The cost fee is missing there. It doesn't exist, and that's directly provided for by administrative code. We are talking about the list of voters, not the list of voters. True. And as to others, and we discussed this with the colleagues, that the courts apply this practice, though this practice could vary. I mean, the fact that the action can be submitted without the cost fee collected, that's what we do all the time. Though the code provides that only for some of the cases, but administrative courts may be based on the principle. Well, it would be interesting to listen to them. Unfortunately, the judge couldn't participate in this webinar because he has a meeting, but they use it as a general law. The action could be filed without the cost fee collected, and based on the outcome of the case, the court decides how the fees should be incurred and collects the respective fee that was to be incurred when submitting the case. If you have a chance, if you can afford paying the cost fee when submitting the case, you'd better do it that, because I think in some instances courts can have a desire to pursue formal approach, and that's a deficiency in a way. We know that time is an issue when it comes to filing the case, and you need to meet that deadline not to lose an opportunity to protect the right. Some other things as to the complaints. As to the time frame, there is an issue with 2 hour, 22 until 22 4 on the day before the voting day. We saw the slide when the commissions failed to handle the submissions. So 22 on the day before voting, that means that between 22 and 24 the Commission can make unlawful decision that cannot be subject to appeal. So there is an issue with that. We have the round of third rounds as well. And are there court decisions that were based on the principle of the rule of law? It depends on the applicants, on the lawyers, on the complainants, on the way you are substantiated. Well, you can't have the situation that there is a decision that was based on the conflict of laws. There is a direct norm of the Constitution covering that, and this time frame until 22 is a violation of the provision. Well, I heard that there is the rotation and the judges on duties in courts. That's an interesting practice that we have today, because establishing territorial election commissions is outside the election process. So how can you appeal or contest that? Under general procedure, you have to prove here that it is related to this subject. If that's the subject of complaint to the election commission, and it was not considered whether the custom of lords was made wrongly or something else, you can prove that. What about the person who believes that it was just unlawful decision, and we don't have any independent observers or anybody else who can contest that? There is an issue with constituencies as well, because we haven't had the registered candidates when the constituencies were delineated, and again, so who is to contest wrongly delineated constituencies? There are lots of claims, and very often the courts dismiss these claims, and one of the reasons for dismissal, not only the merits of the dispute, but very often in the ruling it is stated that it is unlawful subject of complaint. So there is no certainty when it comes to case law. If it is a complaint submitted to the Commission, if the voter submits the complaint, then the voter should substantiate how this decision, action, or inaction violated his election rights. All other subjects, when submitting complaint, does not have this requirement, so they can contest any action, inaction, or decisions without this requirement to be met. Dear audience, if you have any questions, or if something was not discussed in detail, please ask questions. And we are moving over to responsibility. Unfortunately, without the responsibility, any rule is becoming just the rule written on paper. At the previous webinars, we spoke about administrative liability. So today we'll speak more about criminal liability. That was not covered much, and if there is any time, then we'll refresh the information about administrative liability, but we'll speak about delineation between criminal and administrative liability in our presentation. We have two chapters, so that's liability for unlawful actions that violate exercise in the expression of the will of people. That's the old version of administrative offenses, and all articles of this chapter are dedicated to administrative liability for violations related to election rights. If you talk about criminal liability, then that's the section on election, labor, and other rights, but there are special articles related to election rights, articles 157 through 160. All these provisions, all these norms are blanket type of norms, so that means that administrative code and criminal code has liability and description, but to understand the nature of unlawful actions, you need to go to the provisions of the election code. For instance, if you talk about unlawful, wrong information entered to the protocols on tabulation, so you need to go to the election code to figure out the detailed procedure of tabulation. If in the middle of the voting, for instance, there is already a protocol with the results of votes counting with some signatures, and all numbers are there except for the number of the ballots received by the election commission, then without knowing this detailed procedure, you wouldn't be able to understand what would be wrong information, deliberately false information, and the courts therefore take it that if there is a signature or the number that was entered into the protocol prior to the deadline under procedure, then they believe that it was offense provided by the respective article of the code. All the offenses related to election rights are committed deliberately or intentionally, and for instance, entering false information as to the reports is one of them. So that's additional burden of proof to prove intent. If intent is not proved, then there is no corpus delicti then. And for instance, if it is false or mistaken information entered into the report of the candidate as to his expenditures from the electoral fund. So if it is deliberate, then it is criminal liability under Article 1591. If that's carelessness, then administrative liability. So if you can't match it with the administrative code, then there is no liability incurred then at all. This new scene that was added following amendments, because the section on administrative liability and offenses was updated, and this article is 157, 160 that were updated with the new provision added as to additional punishment in the form of banning holding specific activity for the period of 5 years, not from 2 and 5 years it used to exist, but 5 years. That was a proposal of our organization as well, and we reasoned it by saying that this election circle of the general regular elections is 5 years, and if that's the person who was brought to account, though it is directly specified by the election code that the persons that are brought to account for election offenses cannot be members of the election commissions, but anyways we decided to offer this additional guarantee, safeguard in a way that following 5 years after serving the punishment, the person for 5 years after serving the punishment, the person cannot hold respective position. The audience asks the question about the right to issue protocols on administrative offenses by observers. And they say that at the moment the provision is allegedly there. Well, the provision is there. Do you have any case law? There is an issue with the case law, because we know that if it is an issue, and we know that members of the Commission can issue protocols on administrative offenses, but they don't have any template. So the members of the Commission can issue protocols anyways. Yeah, they can, but they should be approved by the respective Commission. Our observers have templates to do that. There is a complexity there, though, that the person should should be presented to the person in question. If that's a law enforcement agency representative who comes and says, "Okay, here's your rights. You need to sign the protocol, or let's call two witnesses," and you should say put. Well, it's kind of effective. But if that's an NGO representative who says something similar, the member of the election commission or the head of the commission subject of the protocol, and typically that would be an issue when the observer is not given the copy of the protocol. So if that's the representative of the NGO who requests to sign the protocol, then the member of the commission just slams the door in front of him, and the observer is to wait for the head of the commission for hours to make sure that the protocol is signed. I think in our case we managed to issue just one protocol only. Lawyers say that well, very often courts can sort of ignore that. Well, unless you have the template that is approved by the Ministry of Interior with all the mandatory columns filled out, then the form can be easily violated, and you can always find faults with it. The CEC is a law enforcement agency when it comes to organizing elections. The powers to hold anybody to any type of account, whether administrative or liability, is not the power that the CEC has. The administrative code clearly establishes the list of documents that should be developed and approved by the CEC. Protocol should be approved by other authorities, not by the CC, as per administrative code. While the TV and radio council, well, they are entitled with the right to issue protocols too. Under Article 212(9), for instance, well, they can state the fact of violation and refer the documents to court. Well, you can't develop the template and approve it. No, we don't have the power to do that. And not a single member of the CEC issued any administrative protocol because there is no template. Okay, let the respective authority develop it and approve it. Well, I don't know if that's CEC. Who is to do that? Well, Territorial Commission should have approved a template. We developed the template because we needed that. Your template, was it accepted in court? Yeah, I did mention that it's very difficult to make sure that the protocol is signed by the person in question against whom the protocol is issued, because the response to this by the members of the commission could vary if it is the representative of NGO and the representative of the law enforcement agency who requests to sign the respective protocol. Given the powers of the police under the law and the national police, and given the liability for refusing, the persons who committed offenses respond differently to the request to sign with the protocol issued against them. I think that it could be the same with respect to the members of the commission, irrespective of the type of the commission. If that's the member of the commission who is drawing the protocol, then the person subject to protocol can refuse to sign it. And how can you seek two witnesses to prove that the person refused to sign the protocol issued against her? But the right is there. It seems to me that any procedure that is implemented, well, should be effective. And if that's unworking mechanism, then there is the question about the viability of this mechanism. And election commissions are entitled with the right to draw protocols. But it seems to me that that's the power that is not is not to be vested with them. So we have lots of examples with administrative offenses when it shouldn't be the authority that sort of brings to account or the authority that has some powers to do that. That's just protocol that's just stating the fact that something wrong happened. Well, the Commission can do that, but that's the issue to be discussed. We understand the complexities. Well, Pavlo Romaniuk sent the comment. He says that the code clearly states the elements to be covered by protocol. The rest is not mandatory. Well, based on this requirements, we try to develop our template. Well, but template is one thing, but practice of doing it is a different thing, and it depends on the case-by-case basis. We're looking forward to the template approved by the CC. Liability. Another question related to liability, indirectly though. The question to you, Victoria, that's about the organization. Tanyana Kiyashko. I looked through the guidance on local elections 2020. I didn't find the procedure of counting the votes. I remember my experience of working as the member of the commission in 2006. I can say that we'll face the collapse because members of the commission will count votes for weeks, and it will take them weeks to submit the documents. You need to prescribe the procedure clearly and train all members of the commission on that, and that's what we spoke about, zero experience. And the best thing would be to fill it, to visualize all steps clearly. We raised this issue at our previous webinars as well. That's on education, awareness, training, methodological guidance, etc. The person is saying that we need to have a really simple, clear, step-by-step instruction expressed clearly and concisely for anybody, so that on October 25 the person could take it out and check what to do. At the CSC, we recently had simulation game to count votes at the polling station. Additionally, we are going to have a number of conferences where we are going to do simulation of vote counting. The first one is going to be in Odessa on October 1. Naturally, that's a painful issue for everybody. We keep discussing it with our colleagues in the CSC, and despite the procedure clearly established by the election code, I think we are going to provide additional explanation. And the guidance, that was the guidance for the TEC members. As to the guidance for PEC members is about to be completed. That's for PECs. I have seen the draft, so naturally it should be polished, and anyways, it contains a very good visual step-by-step instruction, and it's going to be published soon. We have the person in charge of information awareness. We keep publishing infographics. So all this kind of, information awareness and educational measures that are undertaken now are of good quality, and we can see that. We have CC project Prosvita. It is popularized, and Rehevko is very good. He's in charge of education. Respect to him for that. I have a question on that. Again, yes, as usual, the TCs are going to be set up under the election code on October 8-9, no later than that. And we have 2 weeks plus prior to elections, and that's 30,000 plus polling stations and a huge number of people. How are you going to handle that given this short period of time, and how are you going to train this army of people, members of the PECs?
Так, у нас
Changing. They keep changing.
налаштувати якісь.
Well, it's true that it is difficult to fix a certain composition of the commissions for a certain date, and even the trainings that we do for the PECs, even after such training sessions, people change there, and people who have been trained, they leave. Same situation with the TECs. After PECs are formed, for 5 or 4 days, the members would change. There is a problem there, but the CEC is paying quite a lot of attention to training the members of the DECs. Let's proceed to the next important issue, especially as we see that the criminal codes. Okay, to follow on this subject, now we are talking about avoiding one's duties by a commission member. We used to have that offense before, but however, it would be hard to apply it. When one was trying to avoid performing one's obligations as a commission member, and there has always been an issue about what the sanction would be. Would one's competence be terminated in that case, or all sorts of liability would be applied? Today, the provision says that avoiding one's obligations is a criminal, socially dangerous phenomenon without proper reasons, in case if that has led to an impossibility for an election commission to work on the election day. If, for example, a person has not intentionally arrived so that there is no quorum and the morning session would not start, or either before the election day starts or during the time when the votes are counted. So this provision can now be applied because it has quite a clear frame, and the mechanism is quite clear at the moment. What has also changed is part 4 of this article. It used to say that if an official, by using his office, interferes with the work of an election commission with the objective of making it, of forcing it to make illegal decisions. So in fact, that was only about the decision. Now it says that it's either decisions or actions or inaction of either the whole commission or an individual member. So, for example, if the employer affects the behavior, influences a member of the commission so that one would not register a candidate or would not come to a meeting or in some other way, then this can be qualified according to part 4 of this article, because it used to be a gap, and one could only apply that provision via the first part of it. Now, talking about interference with the election rights, here it is important to differentiate between administrative and criminal liability. If this interference has been done without any special way, like use of violence or threats to destroy property, that would lead to administrative liability. For example, if a journalist has not been allowed to participate in the meetings, then Article 171 of the Criminal Code can be applied. If this is about an observer, then there was no liability at all. One had the right to be present, but what if unlawfully that person was deprived of that right? One could only go to an administrative court or a higher level commission. There was no mechanism before. Now it is possible to to apply administrative liability, especially if this was done through duping or violence or threats, only then it would become publicly dangerous and that would entail criminal liability. Article 158, well, this is interesting because this is providing incorrect information to the registration authority. Well, it now says that this is intentional submission of incorrect information about voters. And now the question is that this would not cover the situation when a voter, by changing one's voting address, would in fact indicate not the real address, not the factual address, which is what the law prescribes when the documents have not been submitted, not attached, but the voter should indicate the real, the factual address of one's residence. And if a voter submits another address, then one cannot be brought to account, although it shouldn't be a problem if one can prove that this has been done following voter buyout or some illegal influence. So this would be qualified under other articles of the criminal code. In fact, this is what we already have in those cases about which the CEC has turned to the national police in these situations where in certain locations there were mass changes of the election address and many voters would be registered with one address, which leads to suspicion that there can be some elements of a crime. Article 158-1. It's a novelty, although we have always had this article. That's when a ballot has been given out to a person who is not entitled to have it, when one is not on the voter list, or one would not provide a document. At this election campaign, this would be a passport or an ID card. When they would say, "Oh, come on, this is Mykolaiv, we know him very well." All right, this would be a criminal offense now. And the police would usually come, and if there are observers present, then even members of an election commission would call and would say, "Look, we have 4 observers at our polling station. Please take your passports along." Well, we now have this provision, and it is on the election code, not accidentally, because it really prevents unlawful giving out of the ballots, to the persons who are not present, who are outside of the country. Yes, you have to fight legal nihilism at every level. Sure. The more prevention we have, the better it is. There is a new part of it, for example, illegal dropping of a ballot to the ballot box. We didn't have it before. The draft said that it is putting ballots into the ballot box, but in the process of amending the code, MP Kalchenko said that we do not use dropping it into the ballot box, but putting it into a ballot box. Okay, so this is putting in, this is inserting it into a ballot box. A person who would not have the right to put the ballot into the ballot box because one has not received it or didn't have the right to receive it. So this would be now covered by this part. New part of it, hiding the ballot or destroying the ballot. We used to have a problem where voters would destroy or damage the ballot, and it could only be considered as an act of hooliganism, because the article about destroying ballots is a special one, and it talks about destruction of the ballots by a commission or at the CEC or in the archives. Wait, I still have a question. Except for one's own ballots, what are we talking about? If we study the case law and those judicial decisions, in almost half of the cases that were brought to the court were about situation when a person would come to a polling station, receive a ballot, would say, "Oh, I hate all of you." Usually that person would be drunk, one tears the ballot up, or for example wants to take that ballot back home and hang it on the wall. Well, the question is whether there is public danger in it, or this is an administrative offense. However, that's except for the situation if the intention of that person would not be to hand it over illegally to another person. Well, that's the first part of it. In other words, providing the ballot to another voter or the intent to do it. In other words, the only thing we can do with our own ballot, we can fill it in and put it into the box. All the other actions are covered by Part 1. Well, it's a very dangerous technology. When a ballot is taken out of the polling station, given to another person, and then the circle starts and everything becomes kind of a lawful, because the ballot completely complies with all the requirements, and it's quite difficult to catch the criminal red-handed. Well, and when the police are trained, they're told that such actions have to be prevented in any kind of situation, and theoretical proceedings should be launched, and only after that they would have to find out what the intent was, whether it is covered by the second part, and if this intent has not been proven, then, well, one cannot give the instructions to the police for every kind of situation. True, but when we really have situations when, for example, an elderly person takes the ballot away and goes to the marketplace and then comes back, and well, theoretically criminal proceedings should be launched, but even according to the Code of Criminal Procedures, such criminal proceedings would not have to be closed. In the criminal process, they also had such situations where the violation was not grave. Well, we still have this provision, and if it's a person that has torn the ballot inside the polling station, that would lead to a ballot one has already received. That would be an administrative offense entailing administrative liability. If these actions have been done to another person's ballot, or when some substances would be put into the ballot box with the purpose of damaging or destroying the ballots, that would be covered by Part 1 of Article 158-1, and if that leads to a situation where it is impossible to count the votes, or where the voting would be considered ineffective, then it can lead to a conviction of up to 7 years of imprisonment. It's a grave crime. Now, we talked about illegal destruction or damaging of the documents. There's a special article that speaks about destruction of the ballots at the archives, where it says at the CEC as well. Usually at the CECs, Well, yes, they have the protocols coming from the district election commissions, and the CEC has its own archives where it really preserves a lot of documents. Right, for the national elections, the protocols. This is a part of the election documentation, and now there is this notion of election-related documentation. It has always been a problem because there was no proper definition for it. They talked about election documents, election documentation, election papers. Now it says that this provision is to be applied both to 158-2, 158-3. Now the registration of the candidates to this are also preserved by the CEC, and for example, what we discussed, the falsifying or submitting the persons who have long been dead or other persons who in fact have not given their consent to be registered, it is now covered by Article 158-3 of the Criminal Code, because this is a document that is to be submitted to the Election Commission. It would not cover the consent agreements because this is what the subject should preserve, so it would not be considered election-related documentation. Falsifying, forging, election documentation, well, not much has changed here. The only thing is that we used to have that provision jointly with introducing incorrect information to the register. Now it has been separated as a new paragraph 158-3, and it clearly differentiates between the liability for developing, for example, a protocol of a vote count outside of the commission meeting and introducing into such a protocol of incorrect information. A usual situation where members of an election commission at a territorial commission, they go away to clarify the situation. Clearly they don't want to go back to their villages that maybe sometimes at quite a large distance, and then they would make such unlawful decisions to rewrite that protocol, outside of the polling station. I'm sure that many people have seen such videos at a cafeteria or at bathrooms or toilets. That would be the place where members of the commission would get together to rewrite the protocols. But in most cases, they would introduce the same figures that they used to have in the first protocol. So they would not really change the expression of the voters' will. The breach, the violation, is that they would draw this protocol in an unlawful way. In other words, instead of doing this as part of their meeting, but they would rewrite or copy, in fact, the previous data. So as to this offense, now the liability for it is lower, while introducing incorrect information, a situation we had in Cherkasy that was investigated for a very long time, and then they blamed Excel forms, Excel tables in this. Well, did Excel have an intent? No, they introduced all the data correctly. That's what they claimed, at least. They investigated that case for about 2 years because they had to do a computer analysis, and these people have been convicted, in fact, although these people, one of the parties, as we said it at one of our first webinars, in fact put the secretary of the election commission into its list to participate at the territorial election commission of this current election, but then they replaced that person. But of course we understand that the consequences of such actions would be very different. One thing is to draw the protocol in an incorrect way outside of the procedure. Well, the other problem is when the votes of one candidate are given to another candidate, where the results of the election thus are changed, and of course the sanctions should be quite different. As regards the first part, for example, it says here that if a person has admitted that one has copied it or did it outside of the polling station and has informed the law enforcement agency about that before one is held liable, one would then be relieved from criminal liability. Stealing the stamp, for example, it is now part of this article because it was not in the previous provision. Now this is part of Article 158-3. Now, violating the secrecy of voting. We've always had discussions about that provision. Article 159, the way it is worded here, it's about, in fact, disclosing the expression of the voter's will by the third parties, either an observer or another person who has learned about how the voters have voted, has disclosed it. In 2019, it has become quite relevant. The issues about Article 159 and 212, because many candidates have shown their ballots many times. Well, Article 159 does not cover a situation when the voter discloses or publicly reveals one's vote. But we have seen, for example, the candidates or even the officials and the voters and the head of a regional state administration and the mayors of large cities, they would open it up for the journalists to show how they had voted. In 2019, they would be held liable according to Article 212 as violation of the campaigning rules. There was no criminal liability here. That was administrative liability, which said that then that way they were campaigning on the election day. Now there is a special provision, a new one, which is public disclosing of one's vote by publicly showing the ballot inside the polling station. For example, if one does it on Facebook, well, that would be another article. Well, we're talking about when a picture was taken. For example, when it is then done on Facebook, it is not covered here, because sometimes this provision has been criticized for that, but in fact, it does not apply to such a situation. If a voter publicly on the election day publicly discloses who he or she has voted for, then this is an action that is covered by Article 212.10 as part of illegal campaigning. Violating the rules for funding political parties. Well, at the moment we have had only one situation in the register where a cash accountant has supported one political party, although he had received that money before from other persons, and there was a declaration of that person proving that one had not earned so much money during a year. However, this is about intentional unjust information in the report, and that contribution If this is a businessman or even a political party that is not the subject of the election process, has paid for another political party for campaigning, then formally this should be covered by this Article 159-1. But since this article was worded and established, there has only been one case like that because it's hard to prove it. One has to somehow establish the fact. Well, it's also a question to the law enforcement authorities. Maybe the situation will change, maybe it should be documented, and such practical approaches should be improved, although there are still problems. There even used to be an IFES project that suggested to introduce such comprehensive amendments to Article 159-1 and the Code of Administrative Offenses. So, within the project that we have worked with, we did not cover it, but it has not been adopted yet. We'll see what's going to happen. Okay, now the most interesting thing. We have already mentioned that at the previous webinars. The bribery can be direct bribery or indirect bribery. Direct bribery is when a person offers unlawful gain for the implementation of one's election right while the other person agrees to it. And this agreement, this consent, is the key element to qualify it as direct bribery. So who can be covered by it? It's the voter. The novelty is that it covers also the members of election commissions and the observers. If a political party gives some unlawful gain to a member of the election commission, this should also be covered by the first part of Article 160. Well, let's see how it evolves, this practice. Now, as to who offers it, here we have some incongruence, because those who are held liable are the ones who offer it to voters or to commission members or candidates. Well, the thing is that when it was amended, then they also introduced observers to the first part so that it would not only deal with commission members, but in the second part they did not introduce it. While during the voting the candidates were removed from the first part but not from the second part of this article. But all of those persons are also voters at the same time. So basically, I don't think there is a problem here. And it will be, such situations will be covered by this article, even if someone offers to run for money. Incidentally, it's a new and quite popular subject because there are not enough candidates. That's why if someone proposes to this person who is yet a voter to run as a candidate, then it would be covered by Article 160, Part 1, although there is no comma and a candidate there. Now, unlawful gain or benefit, it is counted as 6 untaxed minimum pays, and this is 63 hryvnias, 6 kopecks. If this is a voter who has received this illegal unlawful gain, that is not over 63 hryvnias, so that means that person would not be held liable. This is the so-called small offense, misdemeanor, sort of, if this is a person who offers it. Then during our meetings with the police, it has been decided that if it's not over 63 hryvnias, this is true about the voter and the one who offers it, then it should rather be considered as unlawful campaigning. There are certain doubts about whether it is correct, but we should of course avoid the situation if it is lower than 63, then that would lead to administrative liability. If it's over it, that would lead to criminal liability, while in the case of direct bribery, the persons who would be responsible for it would not be held liable. So here we propose to qualify it under Article 212-10, while indirect bribery would mean that unlawful gain is offered to the voters if it is accompanied by campaigning or by mentioning the name of the candidate or the picture of a candidate. If, for example, today there is a box of candies, well, candies, that's criminal liability at one because that's foodstuffs.
That's food products as well. Okay, so we are talking about qualification at the moment because the name of the candidate or his or her portrait is there. So the practice that we had before, well, when you had logos of political parties everywhere on the parcel, food parcels, on boxes with apple. So, well, that would be treated as incitement under the new legislation. Unlawful gain covers food product, spirits and tobacco irrespective of the value, and it is liable under Criminal Code 163 if that's monies, then goods, services, etc. And it should exceed the sum of 63 hryvnia to be criminal liable. If it is less than that, then it's administrative liability. Any problematic issues with campaigning materials, as we said, the idea of the provision was to cover campaigning materials, and that would include flags and badges that were produced out of the party cover with the logos and brands. The value limit was to be 63 hryvnia, but we know that when the draft was finalized, so administrative code and criminal code have similar kind of wording, but electoral code doesn't have transition provisions. The CC issued explanatory notes on banning the bribing of the votes, saying that the value of campaigning materials shouldn't exceed 63 hryvnia 6 kopecks. We know and criticize it. While police, jointly with courts, would refer to the tax code, so the subjects of the electoral process should take note of this. On the other hand, I am talking about the subjects of the electoral process. Well, some people are ready to face administrative liability and are going to produce the items worth less than 63 hryvnia. Police should take account of that too. I mean, the damage caused to public health and safety. Well, sometimes I am asked the question like that. Okay, should we call the police if the candidate hands out bouquets of flowers on the 8th of March, well, is there an element of offense about that? In theory, yes, but in practice, would you call the police then? So the candidate is treating voters with coffee at an event. So would it be necessary to call the police if that's his coffee pot that he brought over and offers coffee to the voters? Okay, so there are a lot of nuances around it, but we do understand that this provision should be applied to count real bribing of votes. If it is food parcels that are handed out, we know that some candidates tend to hand out sugar for they have been doing that for years. That's food parcels, but here we need to take into account that subjects of electoral process should exercise their right to a campaign. Well, my personal opinion was that, okay, in the explanations you should have said that, okay, there are printed materials, campaigning materials that are not items per se. So the newspapers, booklets, and other things are considered to be items equal to sugar. But memory sticks, the calendars, flyers, posters, well, objectively, we should understand that the value of campaigning materials, and that includes memory sticks, the T-shirts and baseball caps, shouldn't cost 1 hryvnia. In the Supreme Court, in one of the decisions where the party was the CSC, came to a very interesting conclusion referring to the rule of law, the Gestastian case. So they said that if it is impossible and cannot be enforced, then how can the subjects of the electoral process can lawfully conduct campaigning if the value of the campaigning materials shouldn't exceed 1 hryvnia? Then that would encourage some subjects to, well, yeah, to violate it. Well, the lawmaker on the third attempt incorporated this provision. Hopefully the new draft law 171/1 is going to have a brighter future than the previous laws, and these issues will be governed then. But at the moment, that's subject to discussion. How to apply this norm? There is a question from the audience, right? No, that's the message, a warning message that we are exceeding the allocated time for the webinar. We mentioned most of the norms on administrative liability at the previous webinars. Administrative liability is problematic, and we need to remember the other three norms: public disclosure of the voting results by the voters, destroying, hiding the ballots, and interference or creating obstacles on the way to exercise of the voting right. So that's three new things to be remembered. I think that's it. We had a comment from Tatiana Kiyashko. You have to keep an careful eye over the members of the commission that are in charge of the ballots, different stages of the process. Well, it's based on her experience. We do understand that that on October 25, all members of the Commission of all levels will count votes together, fill out the protocols to make sure that the elections are deemed to be held in most of the constituencies, and that's a super task of all communities and for the commissions of all levels. If you are done, Olga, if you finish, then we will wait a couple of minutes for the questions from the audience, if there are any. And meanwhile, while waiting for the questions, we are going to conclude today's event. It seems to me that it was no less interesting than the previous webinars. Let me thank Victoria Glushenko, member of the CSC, for the presentation, comments, and answers to the question. Let me thank Olga Kotsuruba, the Chief Advisor on Legal Issues of Opora NGO, and let me thank the organizers of a series of webinars that we had, and today it was the last webinar that we had. Organizers are the Council of Europe project on transparency, inclusivity, and fairness of the electoral practice in Ukraine, and Human Rights Platform NGO. Let me remind the audience that you have the recorded webinars. All 8 of them are accessible on YouTube channel, Election Projects of the Council of Europe. A little bit later, they are going to be accessible on the Human Rights Platform NGO. And a short spoiler, hopefully after, or potentially after elections, we'll have another series of webinars dedicated to assessment and analysis of the electoral practice, that different subjects of the election process are in the process of shaping. I think that's going to be a very interesting discussion again. So keep an eye on the announcements, and see you later.